Contented Media presents Dr. Bitcoin, the man who wasn't Satoshi Nakamoto, an original podcast series with Mark Hunter and Arthur Van Pelt.
Hello and welcome to Dr. Bitcoin, the man who wasn't Satoshi Nakamoto, and a quick-fire bonus episode concerning Craig Wright's permission to appeal the COPA versus Wright ruling, which was handed down today. Arthur is off doing family duties, and so you're stuck with me for the next 15 minutes or so while I go through what the appeal judge, Justice Arnold, had to say about Craig Wright's 2,000-page plus appeal filing bonanza. The first thing to note is the timing of Wright's appeal, or, as it turns out, appeals. Wright filed his first permission to appeal on time, but he only mentioned Justice Miller's 16th of July form of order. His second appeal was filed late and related only to Justice Miller's verbal ruling in March and his written ruling in May. Justice Miller allowed Wright 21 days from the form of order to appeal, giving him a total of nearly 3 months to work on his appeal of the May ruling, and he still got it in late. Must be all those casinos he's designing. Even though Wright technically filed the second appeal late, his arguments in the first appeal made it clear that he was actually challenging the main decision, not just the follow-up order. For this reason, he was allowed extra time to get all his ducks in a row, which is only fair seeing as no law firm will touch him. He's chosen to represent himself. As we covered in our appeal filing episode, Wright sought to bring in hundreds of pages of new evidence to back up his arguments, but these didn't cut much ice with Justice Arnold, who ruled thus on Wright's various attempts. Kerry and Jones' affidavit, which outlined the consistency and methodological approach of Dr. Wright in his inventive processes, was dismissed because she could have said everything at the trial and nothing in the affidavit would have affected the outcome. Dennis Miyaka's affidavit was dismissed because Ontier could find nothing useful after supposedly spending a month with him, thus making his evidence not credible, although it is Ontier, so, Stefan Savannah's evidence could have been obtained before trial but wouldn't have made any material difference to the outcome. Wright's expert evidence over email authentication, which we assume is from the Bryant report, could and should have been obtained before trial, but it wouldn't have made any difference to the outcome given the clear evidence that the Myob Ontier email was a forgery. Wright's reliance on case law from Hollington versus Hewthorne was deemed not evidence at all. Whoops. Simon Cohen's witness statement was unsigned and described in the covering email as very much a working draft with some of the details still being confirmed. Even if it had been the finished article, Justice Arnold found that it would have made no material difference to the verdict. And finally, a draft fourth witness statement from Craig Wright was not adduced at trial when it plainly could have been, not that it would have made much difference if it had, it was unsigned and was riddled with comments raising unanswered questions. Justice Arnold also discussed the Craig Wright fan club's new pariah, David Pearce and his clandestine dinners. Justice Arnold found that the only thing Wright's evidence on this matter showed was that Pearce and Justice Miller discussed the handing down date of the ruling at a social engagement 2 months after Justice Miller's verbal ruling. This, he said, does not begin to demonstrate an appearance of bias, let alone actual bias, nor would it have done so even if the judge had not already announced his decision. This is wholly irrelevant, particularly given that Mr. Pearce was not a witness. At this point, it's amusing to note that in Wright's contempt of court hearing this week, which I'll touch on at the end, Wright was given the chance to put these very allegations to Justice Miller live. Naturally, being the cowardly keyboard warrior that he is, he chickened out, blaming someone from Metanet for slipping that section into his appeal filing. Just staggering. Justice Arnold then went over the facts of the case, noting that Justice Miller had the advantage of seeing and hearing Dr. Wright cross-examined for over 8 days on 15 witness statements. This, it seems, was designed to tackle the idea that Justice Miller was too hasty in making his verbal ruling. He had been living with the case and Craig Wright's lies and goalpost shifting for more than 2 years. In answer to Wright's claim that his autism had negatively affected his performance, Justice Arnold noted that Wright had been very well represented, that more measures were in place than for a regular trial, and that no suggestion was made at trial that these adjustments were inadequate or ineffective. He noted that Wright challenged the ruling on no less than 59 grounds which attack almost every aspect of Justice Miller's reasoning. This amounted, he said, to Wright demanding that the Court of Appeal retry the entire case, which he said was totally without merit since it involves a complete misconception of the Court of Appeal's function and approach in a case such as this. He also added that none of Wright's grounds comes anywhere near demonstrating that the judge's decision is rationally insupportable. Wright's backup plan was that the appeal court order a new trial, but Justice Arnold shot this down, noting that this, too, was totally without merit since none of the grounds comes anywhere near demonstrating that the judge's decision is tainted by irregularity. He then had something to say about the content of Wright's appeal when it came to his allegations of bias and misapplication of justice. On the contrary, Dr. Wright's grounds of appeal, skeleton argument, and summary of skeleton argument themselves contain multiple falsehoods, including reliance upon fictitious authorities such as Anderson versus the Queen, 2013 UKPC 2, which appear to be AI-generated hallucinations. Those who listened to our appeal show will remember that Wright cited over a dozen news articles that didn't exist as evidence, which led us to question the efficacy of his case law citations. Some of these, too, therefore, were entirely fictional, which is great work from the man who some of his supporters believe is an actual lawyer. Justice Arnold eschewed the laborious and frankly thankless task of tackling all 59 of Wright's grounds, focusing instead on 10 core ones that it's worth reading out in full. Number 1. Misinterpretation and misattribution of evidence. Dr. Wright claims that the judge misinterpreted various items of evidence and incorrectly attributed documents. His assertions are either new points not raised at trial or contrary to the evidence or fail to engage with the judge's reasons for rejecting them. Number 2. Judicial bias and procedural unfairness. Dr. Wright accuses the judge of bias, but this accusation is baseless. No credible allegation of either actual bias or apparent bias is made by Dr. Wright, but only a series of disagreements with the judge's reasoning. In fact, the judge leant over backwards to ensure that Dr. Wright received a fair trial. The same goes for the accusation of procedural unfairness. Improper rejection of expert testimony. Dr. Wright makes a number of challenges to the judge's treatment of expert evidence, but as the judge explained, Dr. Wright's own experts agreed with COPA's experts on most issues. Having chosen those experts to give evidence, it does not lie in Dr. Wright's mouth now to say that they were not appropriately qualified. Nor can Dr. Wright complain about decisions taken by his legal team with his authority, such as the decisions not to call some witnesses and not to cross-examine others. Dr. Wright argues that the judge should have treated himself as an expert, but given that 1. Dr. Wright was the principal factual witness, and 2. He had appropriately qualified experts, the judge was plainly right not to treat him as a surrogate expert witness. Dr. Wright alleges that the judge wrongly excluded Mr. Bryant's evidence, but this is false. Dr. Wright did not pursue a late application to adduce this evidence. Dr. Wright claims that Mr. Madden was not properly qualified, but the judge explained why he was. Number 4. Reliance on unauthenticated documents. Dr. Wright argues that the judge improperly relied on documents that were not properly authenticated. This is misconceived. The true position is that a document is assumed to be authentic unless its authenticity is properly challenged. Dr. Wright's real complaint concerns a number of the judge's findings of forgery, but without engaging with the reasons given by the judge for those findings, which were largely based on uncontested expert evidence. Number 5. Inadequate consideration of Dr. Wright's ASD. Dr. Wright complains that the judge did not make reasonable adjustments for his ASD. This complaint is baseless. As noted above, the judge made the adjustments which were agreed between the parties' experts on ASD, and no complaint was made at trial that they were inadequate or ineffective. At the end of the cross-examination, Dr. Wright commented positively on the experience. A number of Dr. Wright's allegations under this head are simply false. Dr. Wright even complains that his own counsel intervened on occasion to ensure Dr. Wright did not unintentionally waive privilege, when they would have been open to criticism if they'd failed to do this. Number 6. Improper handling of cross-examination. Dr. Wright complains that his cross-examination was improperly handled by the judge. This is largely a repetition of theme 5. Number 7. Misapplication of legal standards. Justice Arnold gives 4 examples here that I won't go into detail on, but they include Wright alleging that the evidence against him is not compelling enough to warrant the judgment he received, and that Justice Miller wrongly rejected evidence which corroborated his claims, and wrongly accepted hearsay evidence. These were all denied by Justice Arnold. Number 8. Failure to scrutinise COPA's witnesses' credibility. Dr. Wright alleges that the judge failed to scrutinise the credibility of COPA's witnesses. Again, listeners to our appeal episode will remember his 20-page fixation with Adam Back. This, again, is a baseless allegation. In many instances, Dr. Wright repeats criticisms which the judge carefully considered and rejected, or which were not even put to the relevant witnesses because Dr. Wright's legal team appreciated that they were without foundation. Dr. Wright even complains about the judge admitting evidence from Jameson Lopp when Mr. Lopp was not a witness at all. Oh, for fuck's sake. Hi, is that Ringling Brothers? Yeah, are you missing a clown? No, it's alright, just thought I'd check. Number 9. Inconsistent application of legal principles. This is largely a repetition of other themes, in particular Theme 7. Number 10. Procedural irregularities and denial of a fair trial. This is largely repetition of Themes 2, 3 and 5. Dr. Wright even goes so far as to say that his own legal team's failures to adduce evidence and or challenge evidence adduced by COPA breached his Article 6 human rights. This is an impossible contention. Dr. Wright had the benefit of a large, highly expert and well-resourced legal team who acted with his authority and presented his case as well as it could possibly be presented. Justice Arnold summarised the whole thing shortly and sweetly. For the reasons given above, the appeals have no prospect of success whatever, and there is no other reason to hear them. That, then, would appear to be that. Given the amount of time we've dedicated to this case over the last few years, we don't need to delve too much into Justice Arnold's reasoning, because it's what everyone expected, including the ChatGPT references, and they very much speak for themselves. The sand in the timer has almost run out for Craig Wright, and although he can appeal to the Supreme Court, he would be mightily stupid to do so. So let's wait for that filing to drop. As for the response by the BSV community, you know the drill by now. Justice Arnold is corrupt, everyone's against Craig, he meant to lose so that he can rise again from the dead or some such bollocks. Again, this is nothing new, and to be frank, it's getting a little tedious by this point. Now, the rejection of this permission to appeal has no direct impact on Wright's contempt of court hearing, which has been confirmed for December the 18th and 19th in the Royal Courts of Justice in London. Craig Wright, as many will know by now, has been ordered to appear in person following a hearing on November the 26th, when he tried all sorts of excuses as to why he couldn't do that. Interestingly, none of the excuses he brought up a couple of weeks back as to why he couldn't appear in person made it into his filing, and conversely, none of the excuses he presented this week came up at the hearing 2 weeks ago. It's a laugh, isn't it? One of these excuses was that he was going to be too busy designing casinos to attend, which was work he had seemingly taken on after agreeing during the prior hearing to those dates in December. Another excuse was that he was at the risk of assassination, and he couldn't come because he could no longer afford the ex-Secret Service bodyguards that had been discreetly protecting him throughout the COPA versus Wright trial, so discreet that they were actually invisible. Wright's contention was that he could no longer afford them because he had lost his job at Enchain, a job he didn't have during the trial either. At this point, it's worth remembering that Wright has claimed on multiple occasions that he's a billionaire with Lamborghinis and watches that would make a Saudi prince salivate, and yet he can't afford personal protection from those Bitcoiners with sniper rifles who'll be waiting for him in central London, probably the most heavily CCTV'd city in the world. As it was, Justice Miller told Craig Wright, with an admirably straight face, that he could fuck off with that, and to get his Antipodean ass back to Blighty for the trial. This means we can look forward to what will almost certainly be the last hurrah for Craig Wright on December the 18th and 19th, where we could be saying goodbye to Craig Wright and this podcast for good. We have something very special lined up for you to celebrate what could be a momentous occasion, so make sure you're following us on Twitter to find out the what, the how, and the when. Also, if you want to get that episode before anybody else and access to all our bonus content going back 3 years, it's not too late to become a member of the Dr. Bitcoin Supporters Club. Details of how to do this are in the show notes. That's it from me, and that's almost it from Craig Wright. The next you'll hear from me and Arthur will probably be in the 3rd week of December, when we release what may well be a very special last ever episode. Just imagine. Thanks very much for listening, and I'll speak to you again soon. Thank you for listening to this episode of Dr. Bitcoin, the man who wasn't Satoshi Nakamoto. Don't forget to subscribe to the show on your podcast platform of choice to get these episodes the moment they drop. And if you enjoyed what you heard, we'd really appreciate a star rating and even a review to help us get this out to as many people as possible. Our monthly bonus episodes are available to download from our website for a small consideration. And if you'd like to access all these bonus episodes, plus these monthly updates a few days early and other goodies, you can do so by becoming a Dr. Bitcoin supporter. See the details in the show notes for information on how to do this, or head to our website, drbitcoinpod.com. That's drbitcoinpod.com. You can also follow us on Twitter at drbitcoinpod, and you can email us at drbitcoinpod@gmail.com. That's drbitcoinpod@gmail.com. Thanks very much for listening, and we'll speak to you again soon.
You've been listening to Dr. Bitcoin, the man who wasn't Satoshi Nakamoto. Written by Mark Hunter, with additional material by Arthur Van Pelt. Editing and production by Mark Hunter. This has been a Contented Media production.